Yes, Mr. Goodman.
My lords, on the preliminary issue at the heart of this appeal, as whether the defendant's pleaded case that a claimant has to prove IDT to be entitled to damages, my submission is the answer to that preliminary issue is no, and that DMA, the case we just looked at, is an illustration of the principles properly applied, and the county court judge was therefore right to make the declaration he did. I'll come to his judgment shortly. And Mrs. Justice May was therefore also right to hold, as a matter of principle, the claimants did not have to prove IDT, although there are nuances of difference between the appellants and Mrs. Justice May as to what the correct approach in fact was. So I'll outline what I submit as the proper approach. So the Secretary of State imposed and maintained NRPF conditions on each of the claimants, while instructing officials to maintain and not to lift the NRPF conditions in cases where a person affected was not yet destitute. See W at 76. That instruction pertained whether or not they would imminently suffer IDT.
Slow down. Instructing officials not to lift NRPF unless claimant actually destitute, even if claimant at imminent risk.
Yeah.
Thank you.
Of IDT. That was in breach of the Secretary of State's duty pursuant to Section 6 of the HRA 1998, not to act incompatibly with Article 3. Section 7 of the Human Rights Act 1998 provides a person who claims a public authority has acted in a way which is made unlawful by Section 6 may bring proceedings against the authority or rely on the convention right or rights concerned in any legal proceedings, but only if he is or would be a victim of the unlawful act. Section 7, subparagraph 7 states, for the purposes of this section, a person is a victim of an unlawful act only if he would be a victim for the purposes of Article 34 of the Convention. Article 34 provides a requirement, the so-called victim test, that a person is personally and directly affected by the alleged breach. There's never been any question that that effectively broad standing requirement is met here, so one then moves to Section 8. Section 8 of the Human Rights Act, my lords want it, it's page 15 of the bundle. 8.1 provides, and tab 2, in relation to any act or proposed act of a public authority which the court finds is or would be unlawful, it may grant such relief or remedy or make such order within its powers as it considers just and appropriate. And subparagraph 3, no award of damages is to be made unless taking account of all the circumstances of the case, including any other relief or remedy granted or order made in relation to the act in question, and the consequences of any decision in respect of that act. The court is satisfied that the award is necessary to afford just satisfaction to the person in whose favour it is made. The court must take into account Article 41 case law, subparagraph 4. Unlawful act in 8.6 means unlawful under Section 6. The approach to damages, to that exercise for the court under Section 8, is per the analysis of Mr. Justice Green in D in two parts, and asks, first of all, is there a causal link between the breach Section 6 breach, and the harm which should be appropriately reflected in damages. That doesn't mean a causal connection in a tort sense. Strasbourg uses the phrase a more than tenuous connection. And then the second question, is the violation of a kind that should be reflected in a pecuniary award? And I submit that turns on a fact-sensitive analysis. So that's the proper analysis, my lords, as to whether damages should be awarded. Can I take my lords then to, my lords have had a quick look at section 8 itself, that's at tab 2, page 15, and then to Mr. Justice Green's analysis of that at tab 10.
So you want to go to section 8?
Oh, yes, I would like my lords to look at section 8 because it's important. And just to read subsections 1, 3, 4, and 6, and 7. Sorry, 1, 3, 4, and 6, apologies. And the page before, obviously, is section 7. And then, if my lords have had a chance to look at that, then tab 10 is D against Commissioner of Police of the Metropolis. And this is the quantum judgment of Mr. Justice Green in relation to the failures by
Where is it?
tab 10, my lord, page 303.
Yeah.
So this concerned the failures by the police to investigate John Warboys, who had raped who were two victims of a convicted rapist, Mr. Warboys. And so the question here, as you see in the head note, at just below E, the defendant resisted the damages claim on the basis that the claimants had already received payments from earlier civil claims in relation to the act in question, and an award was not necessary to afford just satisfaction to the claimants within the meaning of section 8.3. So in a previous judgment, Mr. Justice Green had found that there was a breach of the investigatory duty. The police hadn't investigated properly under Article 3. So again, the breach of duty here is of a procedural character. It's about the failure to investigate.
Was it failure to investigate allegations before Warboys was unmasked and tried, or later?
Both, my lord. And then I'm going to take my lords to paragraphs 18 and 25. So it's a claim for damages under section 8. Paragraph 18. In relation to any claim for an award of compensation, the starting point for the analysis is to answer the question whether a non-financial remedy is necessary, just satisfaction. In the present case, I've already made declarations in favour of each claimant to the effect that their convention rights have been violated, see the liability judgment. The importance of declaratory relief in an appropriate case is not to be underestimated. It provides a formal reasoned vindication of a person's legal rights and an acknowledgement in a public forum that they have been wronged. It's an integral part of the democratic process whereby a public body can be called to account. Case law suggests that there are at least two components to the question whether a financial award should supplement a declaration. First, it is necessary to consider whether there is a causal link between the breach and the harm which should appropriately be reflected in the award of compensation in addition to a declaration. Secondly, and regardless of the answer to the first question, it is necessary to consider whether the violation is of a type which should be reflected in the pecuniary award. And then at 25, so secondly, in relation to causation, I have addressed in the liability judgment the different question of causality arising between the failures of the police investigation and the apprehension and ultimate prosecution and conviction of war boys. See the liability judgment, section D. In this quantum stage, the causal issue is quite different and focuses on the nexus between the failures in the police investigation and the physical and mental harm suffered by the claimants DSD and NBV. As I explained below by reference to findings in the liability judgment, there's no real doubt but that the violation of Article 3 did cause harm to DSD and NBV, which is quite discrete from the harm caused by the assaults perpetrated by war boys. So the nexus of harm is as between the breach, the failure to properly investigate, and the harm that was suffered from that breach. It's not about the fact that obviously the rapes themselves would also have involved Article 3 issues, but that's not what the compensation is about. It's about compensating for the Section 6 breach of duty by the police.
Are you going to go on and read the sentence as the analysis? That covers the point.
Jurisprudence of Section E below clearly shows the court, without recourse to any expert or medical evidence, quite regularly simply assumes that a claimant must have suffered some form of generalised anxiety, distress or anguish warranting compensation. I'm grateful, Lord, that's a point I made earlier, but
That
more authoritative.
goes to what you said this morning.
It does, yes. I'm grateful for not picking that up. So, bringing those principles across to the case before us, the defendant's breach of duty, as found by the divisional court, was that the NRPF scheme did not adequately give effect to the duty to lift the condition, the NRPF condition, where a person was not yet destitute but would imminently suffer inhuman or degrading treatment. So that breach of the Section 6 duty inheres in a combination of imposing the NRPF condition as an executive decision that withdraws the right to welfare support, combined with the lack of mechanism to moderate that act. So with the one hand pushing them towards destitution, combined with the failure to reel them back from the brink.
But it's the same act. I mean, the difference between the cases we've got to consider and the War Boys case is that there you had two types of misconduct. I mean, you had the rapes carried out by War Boys himself, for which he had to pay compensation, and the failure by the police to investigate and possibly have prevented one or both of those criminal acts. They're different defendants, and what they've done wrong are entirely separate and different, although obviously they both have an impact on the claimants.
Yes.
It's not difficult, not so difficult in those sort of cases to see why the court thought that an award of damages against the police was appropriate to mark what they failed, and it wasn't overridden or removed by the fact that War Boys himself paid compensation. But I mean, in our case, what you're complaining about led both to a procedural breach and perhaps in these cases, also to a substantive breach, but it was the same conduct and it was the same defendant. So,
Yes.
I mean, why in a case where, for example, you're able to recover or would be able to recover damages for the substantive breach, is it necessary to mark the procedural breach by another award of damages as opposed, for example, by a declaration?
The way that the claimants were seeking to put the claims was to obviate the need to prove the substantive breach, as I tried to explain to my lord earlier, because of the difficulty.
That's a matter of convenience to you. I mean, in terms of analysing whether damages would be an appropriate remedy for that breach, you can't sort of say, oh, well, it'd be more convenient if we could get them for this breach, because that would save the court having to go into questions of whether there was IDT ultimately in relation to these claimants. I mean, we have to work on the basis that for some of them, as I think the county court judges found, they did go on to suffer IDT.
Well, in my lord's illustration, there's two breaches, as I put it earlier. There's the breach of duty as found in W, and then there's a further breach in terms of the individuals ending up suffering IDT.
Yeah.
But the fact that they could prove the further breach has no bearing in my submission on whether they can pursue the procedural breach on a more convenient basis as well. Why should they be disentitled from the procedural breach because they also suffered inhuman and degrading treatment? If that's the way they want to pursue the claim, why should they be locked out of a lesser form of breach that's easier to prove because they might well be able to prove a more substantial breach?
But you'd have to be able to, I mean, I understand that argument, but it would amount to saying that they would be entitled to damages for both breaches in the event they decided to press on for the second breach as well.
If ASY, having got her damages for the procedural breach, were then to go back to the county court and say, and by the way, I also want, then the court would be very much in the position that Miss Justice Green was faced with, of the defendant saying, what, you get a second bite of the cherry, which is exactly the kind of considerations that he was looking at. Now, in those circumstances, the court would say, well, under Section 8, is it necessary for just satisfaction for this court to go over all of that again? You chose to do it in this way. That would be relevant considerations. It may be the court would say, yes, actually, in this one case, the egregiousness of the actual experience was such that we do say, on the basis of the violation of the substantive article, fine. But I can assure the court that the reality is what these claimants want to do is restore the order that they've got and settle the claims. That's clearly the proportionate and realistic way forward for all of them.
I understand, but we've still got to be satisfied that an award of damages is appropriate for the procedural breach. I mean, whether they pursue the other is a matter for them, but I mean, because they don't want to, or it'd be more difficult, or it'd take a lot of court time, can't it seems to me increase the justification for awarding damages in relation to the first breach. The first breach has to be looked at in itself, having regard to all relevant circumstances.
Which in my submissions is what the county court judge did, because he gave the same level of award to each claimant regardless of what the breach may have entailed. On the question of whether you have to actually conduct the Section 8 exercise, this court itself, the county court judge did that in a separate quantum judgment. Mrs. Justice May said, if I'm wrong about my analysis of whether there is breach at all, I don't interfere with his assessment of quantum. She says that in her final paragraph. That's not been cross-appealed. So the court may just take the same approach, that if Mrs. Justice May was wrong about breach, it doesn't need to go into the Section 8 analysis because the judge's approach there is not cross-appealed.
Right.
So you have a narrower task than perhaps you'd and maybe appreciated from the way I've put it so far if I hadn't made that clear.
No, we did know that what she'd said about.
Of course, the court knew what she said, but perhaps I was implying the court might need to go through the Section 8 analysis itself. But what I was really trying to do with Section 8 is to explain why some of the anxieties that understandably all English lawyers feel about causation need to be analysed through the spectrum of Sections 6, 7 and 8 and not through importing ideas of causation that might feel natural to us from a common law perspective. So that's why I'm going to Article 8, because the safeguards that we may feel are necessary are in Section 7, you have to be a victim, and in Section 8. They're not in tort-like causation principles that we then bring into the Human Rights Act.
And Section 8.3a would require us to take into account any other relief, which is part of an answer to the two damages.
It is, yes.
I can't remember what the precise terms of the preliminary issue were that is in front of us. No?
Yeah, let's the order of Mr. Justice Potter.
336. So it's 2.
It's at 336, my lord, of the core bundle.
Yeah. Yeah, whether or not have a right to damages for breach of their procedural rights. So, I mean, although you may be right, I mean, perhaps a fair argument, but perhaps, but whether or not it's within the province of this appeal for us to, if we were to disagree with it, to turn over the judge's assessment of damages in these cases. The preliminary issue does require us to say something about whether you've got a right to damages.
Yes.
And I would have thought that does leave it open to us to say if it was appropriate. For example, if we took the view that the declaration would normally be an adequate remedy in these cases, we could say so, couldn't we?
Well, I think what the word right there is trying to get at is an in principle right, because what the preliminary issue was trying to address.
You don't have a right to damages, in fact, do you, if you read Section 8 carefully?
And in principle, so are we in principle in Section 8 territory? I think is what the preliminary issue was trying to articulate, because the background to the preliminary issue was the defendant said no damages unless you prove inhuman and degrading treatment. So that's the principle that the preliminary issue is trying to get to. Do we have to prove inhuman and degrading treatment, or can we prove something else of a procedural character? That's really what it means.
Yeah, but I mean, for other cases, I don't know whether there are other cases,
Yeah.
but I assume there probably are.
There are, yeah.
Yeah.
Stayed.
I mean, the purpose of this appeal is to lay down, presumably, some guidelines for the future, so that the county court judge hasn't got to go into all this de novo.
Well, I would gratefully adopt that indication, because one of the big problems with where we're at from the High Court judgment is they just said respondent's appeal, the Secretary of State's appeal allowed, and I don't really know what I'm supposed to do when I go back to the county court in light of the High Court judgment. So some practical focus on what actually happens would be extremely useful, because to take some illustrations, if the court says defendant wins, you have to prove inhuman and degrading treatment, fine, we'll go off and we'll try and prove that. If the court says what Mrs. Justice May says, you can only get damages if you show there was unreasonable delay in determining your applications, fine, we'll go off and show why it was unreasonable to delay as long as they did. And if the court says, as my primary submission, that the breach in here is in the Section 6 violation found in W, then there's no need to go back because that's the basis on which we've already got the judgment from the county court. But we need a practical indication of what comes next, certainly.
I think, as I read it, one thing which is not an issue is the awards quantum.
Yes.
And that it's not part of Mr. Taman's skeleton argument or grounds of appeal to say that an award of 3,000 should have been 2,000.
Yeah.
I smiled when I saw that your case somewhere puts reliance on the £3,000 awarded in W, because that was, as I recall, a settlement between your team and
Yes,
Mr. Kovacs's team, and very good thing too. But it doesn't have much.
No, it has no force.
Value
I
as a
completely
precedent.
accept that. It was an indicative number. It has no.
And if we were with you in restoring the order of the county court judge, I think, subject to anything either of you says, we would restore the order. We weren't asked to say whether £3,000 was too much or too little. That's not.
Yes, I would endorse
We've
that.
got enough to
indication.
deal with.
Yeah. Yeah.
All right.
So we've dealt with Miss Justice Green, and so bringing across that approach, you've got here a combination of an NRPF condition with a scheme that doesn't allow for applications for that condition to be lifted at the appropriate moment. They had to already be destitute. The scheme inhibited the Secretary of State thereby from complying with the Section 6 duty. In these cases, the Secretary of State prevented himself from having the ability to know whether a person would imminently suffer IDT. That was unlawful. That's what flows from the Divisional Court's findings. Or put another way, the claimants were inhibited from bringing their destitution to the attention of the Secretary of State until the moment upon which they could prove destitution satisfactorily. So these claimants, I say, in answer to the preliminary issue, do not have to show they fell into IDT. Of course, if they can show that, they can succeed on that basis. What they have to show is a nexus between the Section 6 breach of duty and the harm they suffered. The judge was right to find that they could show that, because the judge in the county court was right to find that, because they were subjected to the Section 6 breach of duty of the Secretary of State. They suffered harm because they were denied recourse to public funds. We took as an illustrative point the moment at which they made their change of conditions applications, because by that point everyone knows they were destitute. If there'd been a more flexible criterion allowing imminent destitution as the trigger for application, at least by that point they would have been released from the NRPF condition, but they had to wait till destitute. The alternative approach, which is pleaded, and I took my lords to the particulars of claim, alternative approach on the pleadings is the DMA approach, which was that as soon as they made the change of conditions application, because at that point the Secretary of State required them to already be destitute, and because that was too high a threshold, the Secretary of State's duty was to act immediately to determine the applications and lift the condition, CDMA. In fact, what happened was, in every case, he delayed for between 40 and 62 days. And on any view, using Mr. Justice Robin Knowles' analysis, that was too long. So he says it doesn't really matter whether the duty was to act in the DMA cases within 2 days or within 9 days. He says on any view, 45 days was too long. The same applies. So even if we can't take it from the moment the application was made, we can take it from a very short period afterwards, because the Secretary of State, having compelled destitution as the precondition to making the application, then needed to move very fast to limit the potential for inhuman or degrading treatment. So on that alternative basis, that's also a basis which doesn't involve proving IDT, and therefore one which repudiates the defence pleaded that you have to prove IDT. In essence, in practical terms, it makes no substantial difference to the way in which the judge analysed it in the county court. Now, he relied on the breach occurring at the moment of application because of the breach of duty in hearing in the W floor. But if he in fact had said, well, within 2 days they should have had their applications determined, the same outcome would have eventuated. So even if there's that nuance, there's no real need for the court to go back over the judge's judgment on that point. But either way, the defendant loses on the preliminary issue. Now, the bizarre thing about the judgment below from Mrs. Justice May is that she essentially found that the DMA approach, that you have to act very swiftly upon an application being made, was correct. So she found the claimants didn't need to prove inhuman or degrading treatment, and yet held that that supported the Secretary of State's appeal because it was a different basis to that which the judge had found, even though it's inconsistent with the pleaded case for the defendant. So that's a very odd outcome and caused a big problem for these claimants in that she awarded costs because she decided the Secretary of State was the winner, but clearly she should have decided the claimants were the winner because they proved their point. They didn't have to suffer IDT. So, my lords, can I take you then to the county court judgment and to Mrs. Justice May's judgment?
Yes.
The county court judgment is at 219 of the core bundle.
I'm pretty sure it's Mrs. Justice May, not Mr. Justice May.
Did I say Mr.? I'm terribly apologetic. And of course, having appeared in front of her for several days, should have been aware of that.
There was a Mr. Justice. Somewhere on here.
219.
Yes.
Paragraph 1 on 220, page 220 of the core bundle, identifies the essential question in this case is whether the Home Office can be liable in damages under Section 8 of the Human Rights Act for applying an unlawful scheme to the claimants, which could have resulted in a breach of their Article 3 right not to be subjected to degrading or inhuman treatment in the form of extreme destitution. That's a perfectly adequate and succinct articulation of the issue. Paragraph 2 is the judgment proceeds on the basis of admitted or assumed facts. No findings made in disputed facts. In my submission, there's no error in 4, 5, 6, 7, all summarising W and the background. And then paragraph 23, so the heading on the very footing of 224 is Article 3 in destitution. And the judge rightly identifies at paragraph 23 that destitution is not in itself inhuman or degrading treatment, but someone who is destitute at the hands of the state cannot be that distant from a state of inhuman or degrading treatment. And he then goes through some of the authorities and then sets out at 226 the application of the old regime, all of that without flaw in my submission. Summarises the cases at 29 to 31, and then at 33, when the CCOC application was made, they were actually destitute. The circumstances of the individual claimants show they and their dependents for whom they cared were at real risk of losing the roofs over their heads and being homeless. There was no evidence of financial support being available. Mr. Tarbury tells me that some local authority funded financial assistance may have been available, but I'm left with a clear impression, as was the defendant, that without access to public funds, the claimants were at risk of being left so destitute their Article 3 rights could have been breached, by which he means the IDT, the prohibition on IDT. To adopt the words of Baroness Hale, the claimants who are female and their children were at sufficient risk of rooflessness and cashlessness by being deprived of state benefits until the state deemed them to be actually destitute, as opposed to imminently destitute, which is the new test after W. That's all correct, and he's fully understood all the different categories of imminently destitute, destitute, and inhuman and degrading treatment being different. He identifies the issues at 36. He addresses the decision in W, and at 42 says, there's nothing in the judgment which I consider can be taken as authority for the propositions that there were relevant procedural rights which had been breached, which gave the victims a right to damages. I don't consider I can place any weight at all on the subsequent agreement reached on damages, my lord's point, in that case, which were made expressly with no admission of liability on the part of the defendant. And then at 46, summary of the defendant's submissions, and we see 47, Mr. Tarbury, for the defendant, argues that to make good their claim for breach of their procedural rights, the claimant must do more than show they were placed at risk of their Article 3 rights being breached, rather they must show substantive breach. In short, he argues that there must be damage and causation thereof, as required in a typical claim in tort. It's worthwhile observing Mr. Tarbury was unable to present any case law in which this was the ratio dendi. And paragraph 50, he correctly identifies it was not necessary for the preliminary issue to look at case law and levels of suffering. So he didn't need to get into what amounted to IDT. And then at 55, he deals with DMA. DMA, the Secretary of State, had accepted a duty to provide accommodation to 5 destitute asylum seekers in order to avoid a breach of their Article 3 rights. Guidance required the decision to accommodate to be implemented within days. In this case, there was much delay. The claimants did not claim that the delay caused actual breach of their Article 3 rights, again, correctly articulating the preliminary issue point before him. Paragraph 58. I conclude from the authorities that the claimants, on the evidence in their cases, have a right to claim damages for breach of their procedural rights under Article 3 ECHR in light of the defendant's imposition of NRPF conditions on them pursuant to the application to them of the NRPF scheme found by the Divisional Court in W to breach the procedural right under Article 3. In particular, I reject the contention the claimants must prove actual breach of Article 3, by which he obviously means breach of the IDT prohibition. And then when he turns to remedy, we see equally that he approaches this in an orthodox and appropriate way. Paragraph 60 sets out Section 8.3. 61, as I hope I have made clear in this judgment, I agree with Mr. Tarbury that there is no strict liability, as he put it. In turn, I accept there must be a causal link between violation and damage, which may be non-pecuniary, such as for physical or mental suffering per Rule 32 of the European Court of Human Rights rules. And then he sets out that, and then it sets out at Greenfield, and then having quoted that, he says at 64, in Lord Bingham's analysis of the authorities seen through an Article 6 lens, it's apparent that the law, domestic and Strasbourg, has recognised that modest damages may be appropriate for anxiety and frustration, notwithstanding that the primary remedy declaration and retrial amounts to just satisfaction in most Article 6 cases. Cites DMA, the reasoning we looked at, where damages were awarded for breaches of procedural rights, as he identifies them. And at paragraph 66, insofar as the claimants are concerned, the harm started from the date on which the NRPF condition would have been lifted, had a lawful regime, i.e. the current regime, been applied to them. There then passed a period of time in which Ms. Yeboah was dissuaded from making a COC application because she would not have got through the door of the old regime, and for the claimants a period of time when the COC application was made unsuccessfully because of the old regime was applied. There were further periods of time between the making of successful applications, making of decisions on the applications, and implementing of those decisions. This meant that periods of actual destitution commenced at the very latest when the successful COC applications were made and ended on the implementation of the decisions to lift the NRPF condition. And then at paragraph 69, conclusion, the answer to the preliminary issue is thus, the claimants do have a right to damages for breach of their procedural rights under Article 3 in light of the defendant's imposition of NRPF conditions on them, pursuant to the application of them to them of the NRPF scheme found by the Divisional Court in W to breach the procedural rights under Article 3. And he then invited counsel to submit a proposed order, and unless the parties manage to settle the claims, the case will need a further directions hearing. So that's his judgment, and my submission reflects the submissions I've made today and is without substantial flaw, and so the judge got it right at the county court level. The quantum judgment then followed. We evidently, pursuant to 70, were unable to settle, as he'd encouraged. We've got then the quantum judgment, and I just pick up paragraph 15. Well, sorry, paragraph 10 and 15, so that's page 246 and 247. Paragraph 10, somewhat surprisingly, notwithstanding paragraphs 60 to 68 of my judgment on the preliminary issue, and my conclusion the claimants have a right to damages to afford them just satisfaction in this case, Mr. Tarbury argues the claimants should have nominal damages. And he says, I cannot see how or why a court would conclude that a claimant should have damages for just satisfaction and then conclude the amount of damages should be nominal. And at 15, it needs to be recalled that the injustice in this case flowed from the imposition by the defendant of an unlawful regime which required the claimants to persuade the defendant to destitute. And the defendant was so persuaded in order to lift the NRPF condition, rather than require the claimants to prove that they were in serious need or approaching a state of destitution, in which situation would be some distance from crossing the Article 3 threshold. In my judgment, the cases to which I referred concerned a layer of limited assistance. So he then goes on to determine non-pecuniary damages and pecuniary damages, which he identifies as the sums that would have been awarded in welfare state benefits from the point of the change of conditions applications, had the Secretary of State not taken away their right to access those benefits.
But I take it we read obviously I can see how the period of destitution, of actual destitution, up to such time as they did in fact eventually receive financial support from public funds.
Yes.
Was a period where the judge found in see paragraph 33 that without access to funds they were at risk of being so destitute that their Article 3 right would be breached. So
yes.
It was a case where the level of destitution on the judge's assessment was likely to cross the line unless alleviated by public funding.
Yes, I appreciate my Lord's concerned about this question of an individualised assessment and whether that's required of imminent destitution. But I come back to the nature of the breach that had to be found, and the nature of the breach was that the Secretary of State scheme did not allow for that very individualised consideration. It just had this destitution threshold, and it treated that as enough.
Yeah.
But the problem with that was even that wasn't enough. So it's not that it was too loose. It was not flexible. So it was not flexible enough a threshold. So to say, well, you were destitute, but you might not have been suffering imminent inhuman and degrading treatment is a nuance that's highly unlikely to arise in any given case, but one which ignores the actual nature of the breach. The nature of the breach was the system established by the Secretary of State by which an applicant could compel the Secretary of State to remove the condition that was pushing them to the brink, was itself in breach of Article 3. So there's no additional condition that they need to show on the facts. I suffered Article 3 breach, or, as the case may be, I was at imminent risk of that. That's the whole point of the scheme, was to attempt to meet that duty. That's why he had that destitution threshold, but it was just set in the wrong way, CW, and so it breached the duty under Article 3 and Section 6.
Yes, but I mean the essence of W is, I mean, back over what we've already been through this morning, but I mean the essence of W is that you don't have to have crossed the Article 3 line in terms of your destitution before there's a breach by the Secretary of State. If the system is such that it doesn't cater for those who are likely to cross the line, before they can become in receipt of public funds. But that was a case, just as Judge Cotter has found in these cases, where they would have crossed the line but for state intervention in terms of funding.
Well, I'm not sure I can endorse that he made that finding, because he
trying to make sense of. I mean, he does go
Yeah.
out of his way to make that point in paragraph 33.
Yeah.
Because that brings, I think, the cases squarely within the framework of REW.
Yeah. The terminology he uses there is, I think, reflective of wording of Lord Bingham's in Limbuela, when he says, without access to public funds, they were left at risk of being left so destitute their Article 3 rights could have been breached. I think that mirrors some words of Limbuela as to where the anticipatory duty arises. So what he's saying is they were victims of the breach of duty by the Secretary of State to set up a system which didn't expose them to that imminent risk of IDT. So I hope Lady Justice Whipple's concern in her order has now been addressed satisfactorily. Obviously, she was concerned about the nature of a preliminary issue and so on, but I hope I've now set that out in sufficient detail that the court's anxiety as it came in, that this somewhat jumps ahead of some of the issues you might expect on a preliminary issue, has been addressed. Here, he dealt with the preliminary issue in my submission in a proper way, determined it against the defendant, and then said, go away and please settle. That didn't happen, but he then went on to determine quantum.
Why? I mean, he has a trial of preliminary issue, which ends in an award of damages.
Well, it's not quite that simple, because the problem with the trial of the preliminary issue is that it knocked out the defendant's pleaded case, right? Because the defendant said you have to prove IDT. Once that defence was gone, there wasn't much room left for the Secretary of State, because they hadn't said any nuance on, well, if you've got a right, you have to prove that we delayed too long, etc. That was the heart of the defence was gone, and so at that point,
that's how procedurally it developed.
Was there any resistance to the idea of
I think so.
Judge Walton going on to do a quantum hearing? Nobody said, well, wait a minute, we haven't had the trial yet.
I don't believe that happened. If we've got the defendant's response to claims, it's 312. I can't remember. That's why I'm just looking it up. So 312 was the skeleton by the defendant on quantum. Which just argues the authorities. 304 is the submissions on quantum.
My lords, I'm informed there wasn't resistance to that course.
No.
I'm grateful.
Well,
Thank you.
it seems very sensible given figures involved. There's a limit to how many hearings one should have.
Well, exactly, yes.
We can leave to one side the interesting question of whether you would be stopped from trying to reopen the claims which haven't yet been decided. You indicated there wasn't any great enthusiasm on your side, but subject to that, what happens seems to me quite sensible.
Yeah, so 304 was the defendant's skeleton, and we'll see there that essentially rival submissions on quantum were being made. It doesn't seem to suggest.
Right, where do we go next?
So then,
Mrs. Justice May?
Yeah, so then Mrs. Justice May, and return to the High Court's errors. And I'll take this more speedily. I'll just remind the court of the three grounds as they're pleaded in the skeleton argument, because we're getting to a point now where the court understands my case, and I hope I can zoom through more speedily.
don't feel obliged to speed through it too quickly because this is the judgment under appeal.
Well, yes. But I understand. But I hope that the reasons will explain themselves. The court having, I hope, now understood my submissions rather than have to go over them all in too much detail once again. So my paragraph 54 of my skeleton argument, the first ground was the learned judge misdirected herself on the nature, scope and breach of the procedural right due to in Article 3, so what I've been making submissions on all day long. And then ground 2 is at paragraph 65. And the judge erred by, in her understanding of the COC applications and the scheme, she erred by referring to the claimant seeking damages based on a risk of being denied access to support from public funds when imminently destitute. If my lords just read through that at 66. And then the third ground is a misapplication of what she described as a low-level systems duty. That's at paragraph 73 onwards. So then if we go to the judgment, which is the core bundle 131.
I think it starts at 119.
Oh, apologies.
Tab 13.
Thank you. Yes, well, I was right. 9, and then I think I wanted to go straight to. She sets out the law in similar terms to what we've looked at. I want to go straight to paragraph 54. So Article 3 systems duties. Sorry, can I go back to 39? Sorry, lost my place there. Paragraph 39 of the judgment. Paragraph 39 was, when I invited him, that's my learned friend Mr. Toman, to identify when persons subject to an NRPF condition under the old NRPF scheme would have had a claim for breach, Mr. Toman responded that at its highest, no claim would result unless or until a claimant could establish they'd actually experienced IDT. So same point pursued. His alternative lower point, as he termed it, was that there may be an entitlement to compensation once a person subject to an NRPF condition had brought the fact of there being an imminent risk of destitution to the Secretary of State's attention through a COC application, where the Secretary of State thereafter refused or unreasonably delayed in lifting the NRPF condition. So in other words, the alternative point for the Secretary of State contradicted the point that was at issue about whether you had to show inhuman or degrading treatment. And in fact, cohered with the alternative way that the claimants put their case in the particulars of claim. Because the claimants said either because of the breach in W or because of unreasonable delay, but not in neither case need to show Article 3 breach. So in effect, the alternative was consistent with rejection of the defendant's defence and answering the preliminary issue in the claimant's favour. That's not how the judge did it, as I alluded to, but and then the way that the judge did look at all these duties was in paragraph 50 onwards, which is page 134. And what she does is to bring in a lot of adjectives and categories. She says this: Article 3 has been interpreted as charging public authorities with certain obligations. The nature and scope of these obligations is still developing, and the manner of describing them has not always been consistent. However, they fall into three broad categories of systems, operational, and procedural/investigative, helpfully set out with reference to the relevant authorities by Mr. Justice Johnson in the case of MG. Now, my lord, that's not an exhaustive or even very helpful form of categorisation, because I took my lords earlier to Lord Brown's speech in Limbuela, and what he talks about in the Limbuela duty is that the key question is the state responsible for the breach? And that he says that is to leave aside all the other categories where the European Court has addressed positive obligations, and he says leave aside the framework duty to have a proper system of criminal law in place, leave aside the operational Osman type duty, and leave aside the investigative duty. So what Mrs. Justice May is looking at here are subcategories of what are sometimes called the positive duties, and they're groups of those. But in doing so, she's actually leaving to one side or recategorising Limbuela. So she creates this taxonomy and framework that immediately sets her off in the wrong direction. And then she says the procedural obligation contended for by the claimants in the present case appears to me, so this is not a submission the claimants made, to fall into the low-level systems category identified by Johnson J in MG, as Mr. Goodman in one of his footnotes in his skeleton argument in fact suggested, but that's not in fact what I suggested in the footnote to my skeleton argument. That's page 188 of the core bundle, my skeleton argument before her. And the footnote there is at the bottom, it's footnote 6, and it refers to the first sentence of paragraph 59. So in my skeleton, what I said was, the defendant's skeleton argument misdescribes the test for a breach of the procedural right in Article 3 on which the claimants relied, which was in fact based squarely on the duty described in Limbuela. Footnote, described in Bagdan Avicius as a negative duty, alternatively akin to the lower level systems duty described in MG by Mr. Justice Johnson, which, contrary to the defendant's argument, does not require a real and immediate risk of a breach of Article 3. So I was squarely sitting within what I'd articulated as the Limbuela duty, but saying alternatively, if you want to go into an analysis of these categories, it's akin to the low-level systems duty, not that it is in that category. So the judge then takes that category and decides to see if she can fit this claim within the parameters of what the low-level systems duty, as she understands it, requires. And her analysis that then follows at paragraph 52. Each of the mothers in the present case had an NRPF condition imposed on them already. It was not suggested that the initial imposition of the condition in their cases was unlawful. Each of them in due course made a COC application to the Secretary of State for a condition to be lifted, and in each case it was lifted. It's not said that those decisions were wrong, clearly not, since the effect was allow them to access public funds, nor do I understand it to be said that the lifting of the NRPF condition was in any of their cases unreasonably delayed, though I will hear counsel further on this aspect if necessary. That understanding was wrong, and we did make that point post the draft judgment. See the pleadings in the particulars of claim, which I went to an opening earlier this morning. The case is not put on the basis that any of the claimants sustained destitution to the point of IDT. Their case is that by operating a system found to be unlawful, the state failed adequately to protect them from the risk of becoming destitute, and that jeopardy alone entitles them to compensation. So that is also a misstatement of the claim, because the risk of becoming destitute misunderstands the crucial importance of the meaning of that term. No one disputes they were destitute. by the time their applications were made, the risk was of breach of IDT. And that misunderstanding of these key concepts permeates the judgment. Mr. Goodman's case rests upon an argument that Article 3 systems duty to protect against destitution arose at the time of the NRPF condition was imposed as a condition of LLTR. This must be in effect what the judge below decided, since he awarded damages calculated from the date of the COC applications, on the basis that each claimant must have been imminently destitute at least by then. But that's not what he decided. And again, it misunderstands the crucial meaning of destitute within the policy. The Secretary of State had accepted they were destitute. That's what lifting the condition involved. And then paragraph 54, as Mr. Toman pointed out, if such an obligation were found to exist, it would represent a significant extension of the class of Article 3 systems duties. I do not believe such an extension is justified in principle, or that W is authority for a duty arising at the point of imposition of the NRPF condition. Where an individual is not destitute, imminently destitute, at the time of being granted LLTR, it is not unlawful to impose a NRPF condition, nor is it unlawful to require a person in respect of whom NRPF condition subsists to make an application to have it lifted if their circumstances deteriorate. The proper question is not to turn on the systems duty taxonomy and whether that's being extended. The question is whether there was a breach of Section 6 upon which the Section 8 damages can arise. And at this point, the descent into categorisations leads the judge astray, because once she's decided that it's in this box of systems duty, she then says it doesn't fit that box. And so at 55, she says it follows there can be no violation of any Article 3 duty before a COC application has been made, bringing the circumstances of destitution or imminent destitution to the attention of the Secretary of State for Home Department. And that's because when she reads the systems duty cases, there's a requirement for a generalised state of knowledge. And then in the operational duty cases, which is another category, there's a requirement for actual or inevitable knowledge, like an Osmond type case, that a person was at a real and immediate risk. So at this point, she starts to import a knowledge requirement into the breach, because she's looked at it through one of the positive obligation type categorisations of systems duty or operational duty. Now, the systems duty in any event doesn't require specific knowledge. It's a generalised state of knowledge that all those cases talk about. And obviously that would have been satisfied in this case. So in any event, it's a misapplication of the knowledge requirement in those categorisations. But by bringing that knowledge requirement in, what she's actually doing is upending the central vice that was established in W. Because she's saying nobody can now claim that their rights were breached unless they brought their position to the attention of the Secretary of State. So they can only claim from the date of the change of conditions applications. But the whole vice of the Secretary of State's scheme was that it prevented people bringing their plight to his attention unless they could prove they were destitute. That's the reason that it didn't comply with the Section 6, Article 3 duty. And so what she's managed to do is invert the very problem that created the breach of duty into a point of defence for the Secretary of State, who can then say, well, you didn't tell me. So I can illustrate that by a more extreme example to make it more straightforward. Suppose his policy was, nobody will ever have the NRPF condition lifted unless they have been living on the streets for 2 weeks. So you can only apply once you've been on the streets for 2 weeks. And then he turns around and says, well, you didn't tell me. And it's the same problem, it's just a more extreme end of the problem. So it can't be right that a Secretary of State who creates a scheme whereby he can't be notified of imminent destitution can rely on the failure to notify him. And the judge elaborates on that in paragraphs 71 and 72. We just skip forward for a moment. When she concludes at 72, it follows, in my view, that if these claimants are to identify a relevant violation of their Article 3 right, then they must show that the SSHD wrongly decided their applications to have the NRPF condition lifted, i.e. that in their cases the risk of an unlawful decision identified by the court in W actually materialised, either because their COC application was wrongly refused or because there was unreasonable delay in deciding it. So it's a catch-22, catch-72 in paragraph 72. You can't mount a claim to have been wrongly denied your right to apply by virtue of the W policy unless and until you can show that you made an application and the wrong materialised in your case. Just to keep...
Well, just a minute. I mean, what is she actually dealing with in the section you've now moved on to? Because he says in 68, I mean, it's headed nature and extent of any Article 3 duty. Okay,
Yeah,
so-
and 65, yeah.
But she says at 68, having dealt with what Mr. Justice Johnson, she says, I think it says, I cannot accept that there can be no violation of assistance duty of a person subject to an NRPF condition unless or until they can show they have sustained RTT.
Yes, that's rejecting the defendant's case.
Yes.
So helping me to that extent, because deciding the preliminary issue on the basis that you can show systems duty breach. So to that extent, fine. That supports the case that we pleaded in the alternative. But I say even the basis on which she then rejected all of our claims and said, well, you can only rely on a procedural breach once you brought it to their attention, that can't be right, because the whole problem here is that they weren't entitled to bring their plight to the attention of the Secretary of State. But it comes back to this problem that she somehow allowed the Secretary of State's appeal on a basis that was inconsistent with determining the preliminary issue, either for the claimant or the defendant. So that essentially irrational way of deciding it is quite problematic for the claimant. So even if this court supports what she says on that the systems duty can arise once an application is made, in my submission, the proper answer to the preliminary issue, therefore, is in favour of the claimants. And that's important because without, if the cost consequences are against the claimants, because despite winning they're treated as losing, then that eradicates any chance of damages because they'll all be offset against the damages. So by awarding costs to the respondent for arguing a case that defeated its own pleadings, she created a problem which meant that we couldn't realistically then pursue the case that we'd actually pleaded. So that needs to be corrected as a minimum in my submission. So my Lord wants to go back to that heading 65. She notes this point that they, at 65, that they're entitled to work and provide for themselves. I took my Lords earlier to Lord Brown's comment that that's not very helpful if someone actually can't work. And look at ASY, she was about to have a baby. So that's a generic point of distinction, but it's not the answer that she doesn't carry the weight that she ascribed to it at a number of points in the judgment.
But it also seems to cross over into whether the destitution situation is satisfied or not, doesn't it?
Impermissibly, in my submission.
I'm making a neutral observation.
Yes. And so she says, whilst it may properly be said of the latter that the restrictions imposed upon them have thrust them into destitution, the same is not true of the former class. So she's trying to distinguish people with limited leave to remain subject to NRPF from the DMA and Limbuela cases on a factual premise. But in my submission, the position is materially, for our purposes, the same, because the Secretary of State, fine, they can work, but the Secretary of State saying, in circumstances where you can't work, it's still going to push you to the breach, to the brink of destitution, if you have a baby or if you fall ill. So it's not a relevant point of distinction. There's still a scheme imposed by the state that's thrusting them towards the brink. And then at 69 is where she says she prefers the lower line submission. I've addressed that already, and why I submit that her conclusions on that were inconsistent with the pleadings. I've always submitted that even if that's correct in my submission, she should have allowed the claimant's articulation of the preliminary issue to succeed, because that's the way it's put in the particulars of claim as an alternative. We say, well, if it's not enough to get home on the structural breach in W, then by at least the point at which the Secretary of State should have determined our applications, there was a breach because the Secretary of State delayed too long determining them. That's in the particulars of claim, and it reflects the DMA approach, where the determination of Section 4 entitlement determined those people were destitute, and so the Secretary of State had to move really fast, and as Justice Knowles says, faster than 45 days on any view. So then, going back to the grounds in the skeleton argument, I hope I've made clear why I say ground 1 is made out, and just rely on further articulation there, namely the learned judge misdirected herself on the nature, scope and breach of the procedural right. On ground 2, I've illustrated how the judge erred in referring to the claimant seeking damages being denied access to support from public funds when imminently destitute, and misunderstood the categories and their relevance to the Article 3 breaches in issue. And I further set out the submissions that I've just elaborated on. Then ground 3, this is my last substantial point on the judgment, is that she misapplied the low-level systems duty in Article 3. So I've already explained the low-level systems duty was something which I said was akin to the duty here. I didn't try to put it in that box. But even if you take the judge's attempts to use those boxes, the way she understood the systems duty and the operational duty was itself not reflective of the case law on those. The low-level systems duty applies where the state undertakes, organises or authorises a dangerous activity. Where it applies, the state has to implement measures to reduce the risk of IDT to a reasonable minimum. It's an anticipatory duty that systems have to be in place. The operational duty, which is identified first in the Osman case, which is around police protecting Osman from third-party threats, that imposes a different test, namely whether the state knew or ought to have known of a real and immediate risk. So although purporting to apply the low-level systems duty, she in fact imports an operational duty knowledge component. And I say at paragraph 78 that the error is encapsulated in the judgment at paragraph 60, which is her analysis of the case of CSM. She says it's clearly an example of a case where it was not necessary to the finding of breach of an Article 3 duty the claimant should have sustained serious harm to the point of IDT. Fine, correct. Supports my case, but the circumstances of the claimant in CSM are entirely different to those of the claimants in this appeal. And she makes some factual distinctions. And she says the level of the vulnerability, the gravity and immediacy of risk to his health without daily antiretroviral drugs, combined with his dependencies at detailing, called for the existence of a systems duty in his case. It's to be noted that the discussion and findings concerning breach of a systems duty were predicated on the fact that staff knew of CSM's health condition. Bourne J's identification of the nature of the systems duty, provision of training and information to staff, etc., where to obtain it, C97 of his judgment, nowhere suggests staff at the detention centre were obliged to take any action unless or until they made aware that the detainee had AIDS. So CSM is a case about detention, and the systems duty was to make sure there were systems in place by which people didn't miss antiretroviral drugs. And we've got CSM in the bundle. I'll be quick on this. It's 21, tab 21. On page 762 of paragraph 90 of the judgment, the judge found that the events demonstrated a lack of a sufficient system for making sure that antiretroviral medication was got to detainees under the care of the state who needed that medication. And then at 97, the problem is serious because of the nature of ART treatment and the dangers of interrupting it even for a short time. The possible consequences of an interruption are sufficiently serious to engage Article 3. The provision of training and information to all relevant staff to ensure each interruption is avoided would not be disproportionate in my judgment. Staff simply need to know that the medication must not be missed and how to obtain it. And 99, I conclude there's been a breach of the system's duty. It's agreed that in order to show a material breach of that duty, the claimant does not have to show that he actually suffered serious harm as a result of the breach, though a lack of harm may mean there's no right to damages. The Court of Appeal ruled that this is the correct approach to the breach of Article 2 operational duty in Sar Janssen. I see no reason why a more stringent test should be applied to the system's duty, and as I've said, the relevant duties under Articles 2 and 3 are essentially the same. And he then goes on, under Issue 2, which is at the foot of, well, just below, breach of Article 3 operational duty, to find there's also an operational duty breach. We see that at 105 to 107. That duty would arise where there's a real and immediate, present and continuing risk of relevant harm. Those conditions are satisfied in the present case so that an operational duty arose at all times the defendant by her officials knew or should have known that the claimant required his HIV medication. And then 107, second sentence, the obligation is to take all reasonable steps to avoid a real and immediate risk of relevant harm. In an Article 3 case, that means substantial and significant harm. And then at 109, however, it's necessary to show a material breach of the operational duty. The all reasonable steps test does not mean that any shortcoming was sufficiently serious to engage Article 3. And at 118, however, there is again no evidence the breach caused any harm. It satisfies the test of materiality by a narrow margin given the short period of time which it was involved. I do not consider any damages of a compensatory nature should be awarded for that breach of duty, or indeed for the breach of the system's duty considered above. So again, an application of procedural duties and procedural rights in Article 3 that's inconsistent with the defendant's case. That's the first point. But Mr. Justice Bourne is not dealing with the articulation of the Article 3 anticipatory duty in Limbuela. And when he's concerned with specific knowledge of the officials, that's under the operational duty. The knowledge for the system's duty is a generalised state of knowledge. So what the judge does is say, well, this is a low-level systems duty case. I dispute that. Then she says these are the conditions to low-level systems duty and they have to include knowledge, and I dispute that. And then she treats the change of conditions application as a means of compliance with the duty that she identifies, and says your only right, therefore, is to have that application determined in a reasonable period or not wrongly determined. And she says, I don't understand that to be pleaded, which was wrong, but she says, I will hear counsel further on that point. So in the end, she sent it off back to the county court for a directions hearing in her order, because we said that is a point, so we want to be able to argue that. Unless, of course, we got permission to come here, which we did. But if one is to use these analogies, I submit that this case can, if one wants to look at it through these lenses, primary position, they're not appropriate. But if we look at this as a systems duty case, then the conditions that one might read across from those cases to this are satisfied. And even on an Osmond test here, I submit that the claimant's cases meet the threshold based on the adopted findings of the judgment, paragraph 7, and the judge urging finding otherwise.
Whose judgment?
Sorry,
Paragraph
this is
7.
the judge, Mrs. Justice May. Yeah. So those are my submissions on the judge's errors. That just leaves, my lords, the question of the cross appeal by the Secretary of State. There are 2 grounds of cross appeal. I've addressed them in detail in my skeleton argument. The first is a reassertion of the defence, namely that I have to show inhuman and degrading treatment in order to be entitled to damages. I've dealt with that in the skeleton, obviously I've dealt with that in submissions, don't need to reiterate those. The ground 2 in the cross appeal is that not even a delay in determining a change of conditions application would be sufficient. So even that which Mrs. Justice May found in favour of the claimant's analysis, even that's wrong, and that some other forms of unspecified conditions would need to be satisfied. I submit that's also wrong in law, and I've put in a skeleton which sets out why.
That's your supplemental.
The supplemental skeleton, which I'm grateful my lord's given permission to admit. Essentially, it all falls away if the correct analysis as I've proposed is adopted. So, before I sit down, my final plea is that, unlike Mrs. Justice May, if the court, well, in any event that the court finds that it's made clear what happens next in the county court, because that is a practical component of this. These are outstanding claims in the county court. There are other matters to be dealt with in these claims. We need to know where to go with these issues. So,
Are there other matters to be dealt with anyway?
In these claims, there's
In any event.
in any event, and in case it's stayed behind.
Suppose you're entirely right. What should the judgment of the court be in relation to these?
So if we're
claimants?
if we're entirely right and the court restores the order of His Honour Judge Rowton in the county court, we don't at that point propose to pursue that we need to pursue the claims any further, because these claimants would then both have their costs and a sufficient measure of damages that it's time up for them, they can bow out.
Yes.
So we'd be content for the court to draw a line under it if that were appropriate, or to send it back to the county court for directions if the defendant wanted to make any arguments about the bits that are no longer pursued or any costs or whatever. Send it back to the county court for directions on that bit, but we would be happy to proceed on that footing, because these claims have obviously gone on long enough and gone far enough, and the claimants don't want to wait any longer and rather bring an end to these proceedings. My Lord, for these reasons I ask you to dismiss the cross appeal, allow my appeal in accordance with the indications I've given as to the proper course to be taken.
Yes.
I'm very grateful for this. Anything else?
I've just got one fact-find question
Yes.
on paragraph 2 of the actual judgment in the county court at tab 18. So it's, I'm pretty sure I know the answer to what I'm about to ask you, but it's in the part of his judgment where he's dealing with the introduction.
Yeah.
And he says, this judgment proceeds on the basis of such admitted or assumed facts as were necessary. There's no schedule of assumed facts or anything of that nature, is there?
There isn't anything as convenient as that, my Lord, no.
That's what I wanted to check. I was pretty sure there wouldn't be, because
Yeah.
if there were, it's just in the sense of some preliminary issues, sometimes there's a schedule of assumed
Yes.
facts.
There is the defendant's witness statement, which I took.
Some of the facts are uncontentious. I just wanted to check there wasn't a specific document.
No, there isn't.
Thank you very much.
I'm grateful, my Lords.
Thank you very much, Mr. Goodman. Yes, Mr. Taylor. Oh, actually, sorry, Mr. Amunwa. Right. Mr. Taylor.
Thank you. So before I address the 3 grounds of appeal, I'm going to make a number of preliminary points to set the scene. And the first of those is to set out the no recourse to public funds context. And a helpful starting point for that is the challenge that ran alongside these proceedings, which was the case of ST. And you will find that in the authorities bundle at tab 17. And where I pick up the theme is at paragraph 33 of the judgment. And my lords may have seen there was a familiar cast of counsel in that case. This was the judgment that ran alongside the institution of this claim, in which a number of broader points and challenges were taken with respect to the no recourse to public funds policy. One of which was that this operated discriminatorily or breached Article 14 of the Convention. And the summary of the divisional court of the appeal is at paragraph 33 that by Part 5A of the Nationality and Immigration Act, there's provision made when considering whether an interference with a person's right to respect for private family life by Article 8, it is justified under Article 8.2 to have regard to certain specific matters, and those include by Section 117b3 that it's in the public interest, and in particular in the interest of the economic well-being of the United Kingdom, that persons who seek to enter and remain in the United Kingdom are financially independent because such persons are not a burden on taxpayers and are better able to integrate into society. And then the way that particular scheme operates was analysed in some detail when the court looked at Article 14 and the justification requirement. And there it may be of assistance to look at 166. It's in the context of the discrimination challenge, and the points are made that Parliament has taken the view it's in the public interest that people who wish to stay in the United Kingdom should be financially independent because they are not a burden on taxpayers and are better able to integrate into society, identified as a legitimate aim. Then it's observed that the relevant parts in Appendix FM express that legitimate aim. Roman numerals 4, the 10-year route has been expressly designed with respect to Article 8 rights of the parents of British children who do not meet the financial criteria of the 5-year route, and the Article 8 rights of the British children by enabling those parents to stay in the United Kingdom, even though they do not meet the criteria. It's also part of the legitimate aim. And 5, the imposition of the NRPF condition creates an incentive to find and keep a job. It's also part of the legitimate aim. And then parents on the 10-year route are entitled to work, although in reality, particularly if they are single mothers, their ability to work may be limited in practice by their need to look after their children. And then 8, the potentially harsh effect of an NRPF condition on parents and children is mitigated by 2 linked factors. 1, the condition is not automatically, but rather normally imposed. Parent's child may be imminently become destitute. The parent can ask for the condition not to be imposed. And 2, if the parent's circumstances change, she can apply to have the condition lifted. Mitigation which the parent can invoke any time mean that the imposition of the NRPF condition is a proportionate means of achieving the legitimate aim which has been described. So that is the framework as stood post W. But it's worth looking in detail next at this court's examination of the policy in W, and that's before these changes were made. And we looked at the judgment earlier. You'll find it at tab 14. Now, we looked earlier at paragraph 22 and 23. And this is in part of the instructions that the court was looking at. And what it said as at December 2019, in other words, before the W challenge, was that you can exercise a discretion not to impose or to lift the no recourse to public funds condition code. And the conditions were having provided satisfactory evidence that they are destitute, or that there is satisfactory evidence that they would be rendered destitute without recourse to public funds, having provided satisfactory evidence that there is a particularly compelling reasons relating to the welfare of a child on account of the child of parents' very low income, and 3, having established exceptional circumstances in their case relating to the financial circumstances, which in your view require the no recourse to public funds condition code not to be imposed or lifted. The reason I've taken you to that is that it shows that there was in place, even before W, a more nuanced instruction to caseworkers. And to set the observations which follow in that context. Because what was accepted by the Secretary of State in W, and this was a concession, you'll find in paragraph 8 of the same judgment in the skeleton argument, that applying limbuela, the scheme would be unlawful if it required applicants to become destitute before applying for NRPF conditions to be lifted. Women submitted that on a proper interpretation of the immigration rules and instructions, they failed to give proper effect to the Secretary of State's obligations identified in Limbuela, prospectively to avoid situations in which the applicant's Article 3 rights would be infringed. Thus, if we were minded to allow the claim on that ground, we need consider the grounds of challenge no further. So that is setting the scene. And then in terms of the specific finding of unlawfulness made by the Divisional Court, reliance is placed first of all on a close examination of Limbuela. And there, a helpful summary is paragraph 41. And the key passage from House of Lords judgment in Limbuela that was highlighted is set out there. And I'm reading from between G and H on the page, where it said it's not necessary for the condition to have reached a stage before the power under Section 55 is capable of being exercised. It's not a question of wait and see. The power has been given to enable the Secretary of State to avoid a breach. A state of destitution that qualifies the asylum seeker for support, Section 95 of the Act will not be enough. But as soon as the asylum seeker makes it clear that there is an imminent prospect that a breach of the article will occur because the condition which he or she is having to endure are on the verge of reaching the necessary degree of severity, the Secretary of State has the power, Section 55(5)(a), and the duty under Section 6 of the Human Rights Act to avoid it. So just looking at the ratio there that was referred to, it contemplates a specific situation of an asylum seeker, a person lawfully present in the United Kingdom pending the determination of their claim, with literally, metaphorically, nowhere else to go, being left in a position where he isn't permitted, she isn't permitted to work. That situation is brought to the attention of the Secretary of State. And what is said is that when that situation is brought to the Secretary of State's attention, the obligation is to lift the condition. And the court in W said that makes two things clear. First, the fact that someone is destitute, as the term is defined for the purposes of Section 95, does not necessarily mean that he or she is enduring treatment contrary to Article 3 of the Convention. The threshold of severity which must be reached to make out a breach of Article 3 is a higher one than required finding of destitution within Section 95(3) definition. Second, Section 6 of the 1998 Act imposes a duty to act not only when someone is enduring treatment contrary to Article 3, but also when there is an imminent prospect of that occurring. In the latter case, the law imposes a duty to act prospectively to avoid that breaching.
Can you give an example, Chairman, of a claimant? I don't mean one of the claimants in this case.
Yeah.
But a claimant who is destitute within the statutory definition, but who is not suffering and has no imminent prospect of suffering inhuman or degrading treatment.
Yes. In fact, I do not have to go very far from the facts of this case. Two of the claimants in this case approached their local authority, were granted Section 17 support, that is both accommodation and funding in the interest of the welfare of the children, in a case where that arrangement has been made by the local authority and the application is made to the Secretary of State. The Secretary of State accepts that the individual is destitute. The Secretary of State takes the local authority's assessment of their circumstances as the starting point there. And the Secretary of State then says, you've been assessed as destitute, your child has Section 17 support. I will lift the no recourse to public funds condition. That is a situation where the destitution requirement is met, but one is nowhere near, because of the support provided, or potentially nowhere near inhuman and degrading treatment. I can give two further potential examples. One is individual rights of the Secretary of State. There is a risk to my housing provision. I'm at risk of being rendered homeless. There's a proposal, again, this matches closely the facts of one of these appeals. There's a risk that I'm going to lose the home over my head. That's going to be materializing imminently, I fear. The condition is lifted, or the condition is not lifted on your scenario, but that risk doesn't materialize.
Well, that's the other way around.
That's the other way around, yes.
I speaking myself, I find the first case the more difficult, that a claimant is in fact destitute, not at risk of becoming destitute, is in fact destitute, but has no imminent prospect of being the subject of inhuman or degrading treatment. I quite see the other way around.
So in the scenario where the claimant is assessed as destitute, not having sufficient funds to meet for themselves, but funding is being provided by the local authority because there is a child and accommodation.
But then from that point on, they're not destitute.
But the Secretary of State still accepts they're destitute because the Secretary of State looks at their funds and their ability to meet their essential living needs and their accommodation. So the fact that somebody has stepped in, the local authority in this case, under Section 17, doesn't mean that the Secretary of State doesn't lift the condition. And in fact, in two of the claimants in this case, that was the position when the no recourse to public funds condition was lifted. A third position, this again is one of the three claimants, individual is in financial difficulties because of other funding commitments. Scenario, one of the families, again here, child is at university, child is a non-British national, not eligible for student loan. Progressively, as the course of study is pursued, the financial situation becomes progressively worse. In that situation, an individual may be assessed as destitute, they haven't got sufficient funds. But that is quite a long way away from a finding that this individual, that particular situation is close to inhuman and degrading treatment. The consequence of it not being lifted may be that courses of studies can't be continued, maybe that cutbacks need to be made, but again, one is looking at a different scenario to the inhuman and degrading treatment threshold, which is at the heart of an Article 3 claim.
Well, I suppose in a way we've got the House of Lords to blame for this problem, sort of suggesting that there were degrees of being destitute that didn't cross the line, and not being terribly clear when the line was actually crossed. I mean, obviously it's not something that can be dealt with, save on a case-by-case basis, but it is just reading the various features. It's not entirely clear at what point it's suggested you do cross that line.
But the unhelpful answer is much of this depends on the facts of the case.
Yes.
I mean, to take one example, single, vulnerable, disabled female on the verge of losing roof overhead and enduring homelessness.
Yes.
It wouldn't take a great deal of time there for there to be an inhuman and degrading treatment problem. At the other end, individual who temporarily gets into financial difficulties, loses job, is able-bodied, has to spend some weeks sofa surfing. Destitution is probably satisfied in those situations, but individual is able, sees light at the end of the tunnel, and is not anywhere near a situation of inhuman and degrading treatment. The combination that was so difficult in Limbuela was that these were not just individuals who were enduring homelessness. These were individuals without that light at the end of the tunnel. Their prospect of homelessness was, in the medium term, indefinite. There wasn't a permission to work. There wasn't a permission to get back on their feet. There wasn't a Section 17 Children's Act, local authority prospect. And the combination, the House of Lords found in Limbuela, of being in that situation and not having a prospect of getting on one's own feet, of having the state keep one in a state of limbo, homelessness, of not being able to meet one's essential needs. That was the difficulty.
I mean, the Section 95 definition, you would think in most cases would be more or less decisive. I mean, it differentiates between people who've got a roof over their head but can't otherwise afford to support themselves and perhaps even feed themselves, and those who can afford to feed themselves but don't have a roof over their head and presumably can't afford to put one over their head.
The people it's designed to catch on the wording is the ones where the roof is still over their head, the finances are continuing, but the clouds are gathering.
Yeah.
On a monthly basis, the individual isn't able to meet rent, isn't able to meet essential living situation. There one arrives at a state of destitution fairly soon. Hopefully one doesn't arrive at a state of inhuman and degrading treatment. But the reason that this particular differential is being highlighted here and highlighted elsewhere is because the state has, acceptably for a number of convenience reasons, adopted these broad categories of destitution. It means that there is a degree of headroom, there is a degree.
For better or worse, the House of Lords has told us there is a distinction between the level of deprivation necessary to bring you within Section 95 and that required for Article 3.
Yes. And that particular headroom is then increased, again for the good policy reasons outlined by the concession made and the amendment made. This is paragraph 8 in W. That if the conditions are not merely that one is imminently at risk of IDT, but if one is imminently at risk of destitution, this is paragraph 8, at that point, caseworkers can and should be obliged to lift the condition of no recourse to public funds.
Although as expressed as a concession in that case, that's just applying Limbuela, isn't it? It's not wait and see.
It's the very same spirit. The way it's slightly more generous is that it applies the Limbuela test to the higher destitution threshold. So we've got the double protection. One, the destitution threshold is higher, and two, the concession and the policy amendment made now provide that if you're at risk of destitution, not merely at risk of IDT, the obligation is to lift.
Can I just so I can understand your answer at the very beginning to my Lord Justice Bean's point about the Section 17 support. That can be provided even though there's a no recourse to public funds condition.
Yes.
And did you then go on to say, in that factual scenario, the condition would then be lifted because of the destitution?
Yes.
So that analysis of destitution doesn't take account of the Section 17 financial support.
That is correct, and I can take you to the facts of in two of these cases. That's in fact what happened. If one advantage for the Secretary of State processing of these applications is if the local authority has made that assessment, the Secretary of State then
Just adopts it.
So that is the good in W. The problem identified by the Divisional Court is paragraphs 66 and 72. And this is really an answer to a submission made by the Secretary of State. Is that in the version of the instructions that the court was looking at, the instruction used the word not just destitute or would be rendered destitute. That's the passage we looked at a moment ago. But then as Mr. Kovacs accepted, the section of the instruction where those words were used does not suggest that there's any duty to act in this and other situations. Paragraph 66 towards the end, I'm looking 5 lines on the bottom, even applying the broader and less focused approach, reading paragraph Gen 111A and the instructions together, we find it's impossible to identify the message that the Secretary of State is under a legal obligation not to impose or to lift the condition in NRPF in a case where the applicant is not yet suffering but will imminently suffer inhuman and degrading treatment without recourse to public funds. On the contrary, the message conveyed seems to be that in that category of case, the decision maker has a discretion whether to impose or lift the condition. This, in our view, has the potential to mislead caseworkers in a critical respect. It gives rise to a real risk of unlawful decisions and significant and certainly more than minimal number of cases. Now that is the crux of the finding in W. What you will see isn't said, and in my submission couldn't sensibly be said, is that there is something in the guidance or in those instructions that prevents individuals from making their applications before that state is met, or that prevents the caseworkers from lifting the conditions, because it says in terms, this is the passage we looked at ago, or would be rendered destitute. And I can take you to the applications made by these claimants. That is wording reflected in the applications too. So the gravamen of what court was getting at in W wasn't that caseworkers couldn't lift the condition early, and wasn't that individuals couldn't make their applications early. It was that because it was expressed as a discretion in that context, it didn't make clear that there was a duty to lift the condition when those circumstances pertained. In paragraph 71, just before we get to paragraph 71, insofar as one is looking at families and children, there was a submission made by Mr. Kovacs. Whatever may be the general situation, considerable emphasis on, I'm looking at 69, emphasis on the exception where there are particularly compelling reasons why the welfare of a child has been received of a low income for lifting the condition. The argument was made that that support was given to an applicant with a child who is not yet suffering but will imminently suffer inhuman degrading treatment. However, as Mr. Kovacs conceded, many applicants with Article 3 rights will have no dependent children, and exception B would therefore never apply. But for what it's worth, it is a wording that was in place when these applications were made, which would have applied to these individuals. The overall conclusion reached by the Divisional Court, paragraph 71, that it could not be said that paragraph Gen 111A of the Appendix FM was incapable of being operated lawfully in all or nearly all cases. And then, just so you have the point on why the destitution threshold was set as it was, between D and E, I'm reading 4 lines from the end. Given the difficulty of identifying the point at which treatment crosses the Article 3 threshold, the Secretary of State has sensibly avoided referring directly to inhuman degrading treatment and instead used the concept of destitution as defined in Section 95. And then the conclusion reached is for these reasons the claimant succeeds on ground 6. The NRPF regime comprising Gen 111 and the instructions read together do not adequately recognize, reflect or give effect to the Secretary of State's obligation not to impose or to lift the condition of an NRPF in cases where the applicant is not yet but will imminently suffer inhuman and degrading treatment without recourse to public funds. In its current form, NRPF regime is apt to mislead caseworkers in this critical respect and gives rise to a real risk of unlawful decisions in a significant number of cases. To that extent, it is unlawful. And I say at the outset that one of the challenges the claimant has in this case is that that is the ratio of W. W says nothing in terms about preventing, precluding an individual making their application early, making application at the point where destitution has not yet set in, but might set in. And that's one of the issues that I will be addressing in my submissions. Just before we leave W, one particular aspect that I just wish to highlight before we turn away from it is on page 486, I'm looking at paragraph 41. And I'm looking at 5 lines from the end where it said that the power to lift or the power to provide support has been given to enable the Secretary of State to avoid the breach.
I'm sorry, I can't. Where in paragraph 41 itself or in the quotation?
I'm in the quotation.
Oh, by letter H.
Yeah.
Yeah.
The next preliminary point I have is that this case aside, I have found one authority where this particular point was actually argued between the parties and the decision judgment was given on it, and that is HA, which is at tab 25, page H23. I flag it up at this point because it adopts the approach that I say is appropriate to be followed in cases of this nature.
Mr. Bates, but not the famous one.
Tab 24, apologies.
Yes.
Now that is a case which involved individuals who had been assessed as destitute for the purposes of Section 95, in other words, asylum seekers. They had received temporary support. I'm looking at page 825 under Section 98. Committed, made payments to cover essential living needs. And the criticism made was that it had taken the Secretary of State too long to provide the requisite support to meet accommodation and essential living needs thereafter. The said that there was therefore an imminent prospect of a breach of Article 3.
Yeah.
And a damages claim was presented. And I'll pick up the judgment where at 843, when Mr. Justice Swift looked at the damages claim.
So, oh, I'm sorry, but which tab are we looking at?
Tab 24.
Oh, I'm so sorry. You must have wondered what I was saying about this debate. So
No, I think you did.
I thought you said tab
I
25.
said you,
did
I
say
said you into the
25.
wrong.
Right. Okay. Back to 24. Right. Sorry, I've been trying to work out what tab 25 had to do with anything. But,
So these are individuals assessed as destitute.
right.
They'd received Section 98 essential living needs support before that. But following the destitution assessment, the complaint was essential living need accommodation was not met in time. And I'm looking at the summary of the argument on page 843.
This is on the Article 3 claim.
On the Article 3 damages claim, where it said these claims rest on the premise that in situations where applications under Section 95 of the 1999 Act are made to the Home Secretary, Section 6 of the Human Rights Act imposes a duty on her to act where there is an imminent prospect that the applicant will be subject to inhuman degrading treatment in the form of destitution. Reliance was placed on Limbuela. And the passage from Limbuela is set out. Submission made in this case is then summarized. It's being said that because there's unlawful act under Section 6 of the Human Rights Act, that extends beyond situations of actual or substantive breach and covers a situation where there can be an imminent prospect of a breach of convention right. Judgment in W is prayed in aid. And then the appropriate approach is paragraph 57. Starting point is a finding of fact being made as to whether Article 3 ill treatment has occurred. The submission was made. For present purposes, the decision of the Home Secretary that Section 95 support should be provided was synonymous with an admission of a breach of Article 3. The judge disagreed. In Limbuela, Lord Hope had said in terms that Section 95 destitution standard was not per se Article 3 ill treatment. The consequences for K and NY is that the Home Secretary's acceptance that each met the standard for provision of Section 95 support is not an admission that their Article 3 claim or their Article 3 claims. Rather, each claim must depend on their facts, taking account of the extended reach attributed to Section 6 by Lord Hope in Limbuela, and then the individual cases are considered. Case of K, relevant period between December 2021, August 2022, and the application for Section 95 support was approved. During this period, she and her children were provided with accommodation by a friend. However, case evidence is effective so far concerns the need for food, clothing, and other essentials. She lived hand-to-mouth existence, received some support from the local authority, weekly vouchers in £74, post office. The vouchers came by post, did not always arrive on time, obtaining occasional assistance from charities, from friends, and food banks. Except that case evidence described an existence that was in many respects wretched, particularly for a young child, went without for many occasions. However, I am not satisfied that this evidence describes matters that reach the high bar that is set for Article 3 ill treatment. Case claim under Article 3 therefore fails. NY's claim again, too, is set out. Dispersal accommodation was provided, did not receive payments needed for essential living needs, reduced to asking at shops for leftover food, children became lethargic, visibly thinner. And the finding of fact made is that no acceptance that what happened crosses the threshold for Article 3 ill treatment. NY's Article 3 claim therefore fails. Now, I've set that out right at the outset of my submissions because it reflects the approach that I'll be inviting you to take in a moment with respect to the damages element in this claim. But before I take you to the judgment below and the grounds, my submission is that what is being contended for here is in fact a double extension. The extension comprises two parts. One, a claim in damages or violation of the prohibition on inhuman and degrading treatment without the individual having been subjected to such inhuman and degrading treatment. And two, a damages claim made for failings said to run or to incept because of matters that occurred or didn't occur before the destitution situation was even brought before the Secretary of State.
Sorry, did you say failings to run?
What is being said is that an Article 3 breach entitles a claimant to damages. In respect of matters that preceded the bringing of their situation, a specific situation.
No, I understand.
So those are my preliminary points. I then just wish to take you to the pleadings, which started this morning. And just with respect to the particulars of claim, I wish to flag up that the particulars of breaches set out of paragraph 370 onwards and you see that reliance there is placed on the claimants.
Just remind me the page, would you?
370. Say that in keeping with findings in Divisional Court in W, it's a violation of the claimant's procedural rights pursuant to Article 3 ECHR in denying them access to mainstream benefits when they were or would imminently be destitute. In each case, the defendant imposed the NRPF conditions that were liable to lead to inhuman and degrading treatment, but failed to operate the system, anticipated and obviated that risk. Paragraph 17, in the circumstances, each claimant has suffered breaches of the procedural rights under Article 3 rights thereunder. And then you'll see under the pecuniary loss claim, paragraph 32, all other claimants claim for loss of welfare benefits that they would have received from their change of condition application until the date of the defendant's decision in an NRPF condition. This claim is without prejudice to the contention that the deprivation of recourse to public funds was unlawful prior to the change of condition. However, damages for pecuniary loss is claimed from the date the change of condition application, at which point the defendant was apprised on the facts and evidence that the claimants were destitute and or at imminent risk of suffering inhuman and degrading treatment without recourse to public funds. Two observations I make on that. That's not the basis upon which the county court judge made his ruling on the point at which damages run. And secondly, it resembles, it's rather close to the analysis of Mrs. Justice May, and that she said if one is to have a damages claim run, the earliest point at which it can run in accordance with Limbuela and in accordance with the jurisprudence is from the point of time when the individual circumstances are brought to the Secretary of State's attention.
Can we just go back to 16C of this pleading? You probably say that A is wrong in principle and B is wrong in principle. What's wrong with C?
C meets the judgment rationale of Mrs. Justice May, in that C would survive Mrs. Justice May's judgment because it pitches the claim from the point in time when the facts, the circumstance, in my submission, it'll inevitably be a circumstance change that will be brought before the Secretary of State, because the initial grant will be of leave to remain on certain conditions. The individual then comes to the Secretary of State and says, my circumstances have deteriorated, my situation has changed. That 16C in a nutshell is the judge's approach below. But my submission is that in a scenario where the individual complains that the application was not dealt with expeditiously, but inhuman and degrading treatment was not in fact sustained. It could be for a number of reasons. It could be in 2 cases by reason of Section 17 support being in place. My submission, that is not sufficient to found a damages claim. It may be sufficient to find finding of breach on the part of the authority. In fact, it will be sufficient to find potentially a breach on the part of the authority to apply the policy correctly, to lift a destitution NRPF condition. But I'm saying my submission is more is required in order to bring a damages claim in just satisfaction for violation of the prohibition on unlawful and inhuman treatment.
And when you say more is required, could you just give an example of what that more might be?
That more would be an individual showing evidence that, in fact, in their situation, inhuman and degrading treatment had been suffered in consequence.
Well, by definition, because we're talking about Article 3.
I misunderstood the question. Yes, I mean, a scenario would be a young family left without a roof over their head for a considerable period. An example would be a particular vulnerable disabled individual being left without the requisite shelter, being left without the requisite support. The unhelpful response is, again, that a lot of these claims will inevitably be fact-specific. It will depend on the vulnerabilities of the individual, on the circumstances, potentially on the prospect of light at the end of the tunnel. Is the individual in a position imminently to help themselves? Where like cases, by definition, won't be. But my submissions, yes.
No. I mean, can I just? I mean, I'm sure you're going to develop this, but can you just unpick this a bit? I mean, what I think you're saying is that for there to be, is this right? For there to be a damages claim, based on the inadequacy of the system, there has to be a finding that as a result of that inadequacy, the individual claimant did go on and suffer IDT.
Yeah.
Now, in those circumstances, they would have, potentially at least, a claim for breach of your substantive duty, because it's actually occurred. It's not just a question of you not having prevented it. I mean, they've gone on to suffer it, for which would, I imagine you would accept, sound in damages. But are you therefore saying that in those circumstances, that has the effect of, if you like, making the appropriate remedy for the, if you like, prior or additional procedural breach, not a declaration or something of that kind, but not a remedy in damages?
Yes, I'm not in a position to resist a declaration that the Secretary of State, in a case where the destitution condition or the condition is not lifted in circumstances where imminent IDT may be feared.
Yeah.
I'm not in a position to resist a declaration to that effect. But the submission is that cases where damages are sought, the starting point is, has the individual suffered a violation of their Article 3 right?
Yes.
That Article 3 right is the right not to be subject to inhuman and degrading treatment.
Yeah.
And part of the rationale for introducing prospective obligation is to make sure that that doesn't happen.
But is the award of damages, which you're then contemplating, if that condition is satisfied that they have actually suffered that, is the court on your analysis awarding those damages for that substantive breach of Article 3, or are they awarding those damages for the procedural breach because it's, do you follow that it's led to that?
I mean, I've set out the headline point, which is that Article 3 damages are for the substantive breach.
Yeah.
It is slightly more complicated. There are two caveats to that. The first one is that the European Court of Human Rights has always recognized that individuals may recover damages for breaches of their procedural, I now use procedural in the sense of investigative.
Yeah.
Right. By definition, an individual will not, in those circumstances, necessarily be in a position to point to a substantive breach, because the whole point of the investigation is the individual says, this needs to be looked at. I've raised an arguable claim. State, why aren't you investigating? Then in those circumstances, there is a well-established jurisprudence that you can recover damages for frustration, anguish, because the investigation is not undertaken or because it is proceeding too slowly. So in the investigative obligation under that strand, that is well established. The second caveat, and this is the cases that I drew to the judge's attention below, and I've got them in the bundle again, is that there have been occasions, and I'll take you to them later, there have been occasions when the European Court of Human Rights has awarded individuals damages in circumstances where they were saved at the aircraft door, saved at the prison gate from treatment, which would have amounted to Article 3 mistreatment. And in some of those cases, I'll show you, damages were awarded for anguish, frustration. Which foreshadows the fallback argument that I ran in front of Mrs. Justice May, having taken her attention to these cases, which was that if I was wrong on the primary argument, then at the very least what an individual would need to show is that they brought themselves into a position analogous to those. And I said the starting point for that is that the individual has put the facts that are being relied upon, facts that it's being said the Secretary of State needed to be responsive to the attention of the Secretary. Just before I leave the pleadings, though, because pleadings points were being taken earlier, can I just say, take you very briefly to the points where these submissions and these points of resistance to the damages claim were foreshadowed in the defense. Because you didn't look at those earlier, and I just wanted to flag them up. And you'll see the defense from page 352 onwards. 12E said the claimant's change of conditions applications were all permitted and the NRPF conditions were lifted by the defendant after due consideration. Change of condition applications were accepted in order to prevent the claimants falling into destitution. It's not understood how in those circumstances it can possibly be argued that the policy was applied unlawfully. F, the application of the NRPF scheme in the claimant's cases was not unlawful. The imposition of the NRPF was lawful at the outset. The condition was reasonably lifted following appropriate consideration of the applications to prevent falling into destitution. 13.2 must establish alleged unlawfulness by reference to their situation. 13.3, there was no unreasonable prolongation in the denial of mainstream benefits. 13.4, there was no delay in administration of the change of condition application, which were considered within a reasonable time frame. And then 32 to 34, it's noted that the claimants accept that the first time the defendant was appraised of the facts giving evidence that the claimants were destitute and or imminent risk of suffering inhuman degrading treatment without the cost of public funds was when the change of condition applications was made. The defendant cannot therefore be criticised for the imposition of the NRPF condition prior to the provision of evidence demonstrating the destitution, imminent or imminent destitution.
Right. If you're about to move on to a new topic, if you've done with the pleadings, would that be a convenient moment to stop?
I'll show you one more document before you rise, which is where I say a helpful summary of the European Court of Human Rights thinking on this is found, which is the guide right at the end of the authorities bundle.
Professor Stoyanova.
Tab 45. 45. And these are documents that are now produced by the Court of Human Rights as overall guides to their jurisprudence. And with respect to Article 3, the structure in the guidance is as follows, and I'll show you that it's also reflected in the case of tomorrow. So the first aspect, it's Roman numerals 2 on page 1897. It's the prohibition on torture, inhuman, degrading treatment, punishment by state agent. And that is inhuman, degrading treatment inflicted by the state. And that is prohibited in absolute terms. And the second aspect of Article 3 is described as the protection from torture, inhuman, degrading treatment, punishment administered by non-state actors. And that you will see from the headings. It's described as the scope of the positive obligations of the state. And then the third aspect is the duty to investigate allegations of torture, inhuman, and degrading treatment. That is what the Court of Human Rights refers to as the procedural obligation. You'll see that under the heading below. And the passage that in my submission foreshadows and reflects the domestic jurisprudence that I will take you to tomorrow is from page 1917 onwards, where there is reference to the scope of the positive obligations of the state. And those are described as, under the nature of the positive obligations of the page, 1, the duty to set up an appropriate legislative and regulatory framework. And 2, the duty to take preventative operational measures. terms of how that dichotomy breaks down, (104) describes axiomatically the provision of a health service, looking after individuals who are particularly vulnerable or under the exclusive control of the authorities. And 105, in context of domestic violence, the court has held that obligations would usually require the domestic authorities to adopt protective measures in the sphere of criminal protection. And then operational measures, sometimes referred to as the Osman duty, that is the positive obligation to protect individuals. I'm looking at 108. For it to arise, it must be established that the authorities knew or ought to have known at the time the existence of a real and immediate risk of ill treatment from the identified individual. Just to flag up the route that I will be taking, I will be saying that if one starts from the position that an individual is applying for leave to remain in the United Kingdom and is applying for that on the basis that there won't be recourse to public funds, but that the individual will have access to work, will have all the autonomy that brings with it, will have access to contributory state benefits, as we look at tomorrow. My submission will be that that is the most apt and the most appropriate rubric to look at the Article 3 obligations that are being invoked.
Well, I'm sorry, I've obviously missed something. Why are we looking at summary of cases involving non-state actors?
Because my submission will be that what is being sought here is the assistance from the state by way of provision of public funds by individuals who are not prohibited from working, who are not restricted in their autonomy, but who are given leave on certain conditions, and who are invoking the state's assistance, who are seeking help in circumstances where the state is being asked for something positive, is being asked to provide them with assistance. And I say that situation is a long way away from Limbuela, and I'm saying my submission would be that it's for that reason that the judge was right in the judgment below to look at whether any of the operational or systems obligations apply.
But the expressions in Limbuela of what can amount to inhuman and degrading treatment, you're not seeking to distinguish those, are you?
No.
But I mean, is the point you're making, I mean, the asylum seeker comes here and is unlikely to be, I mean, is going to be utterly dependent on the state for their, I mean, they can't work. They come probably without any prospect of finding accommodation and so on. And therefore they're in a different situation and must be taken to be known by the state to be in a different situation from the class of claimants we're concerned with, who get their permission to enter on the basis that they're coming to work and can work, obviously, and they agree that it will be on terms that they don't seek to support themselves from public funds. So that for them, there has to be a fairly fundamental change in their circumstances, and then it's a question of at what point does that engage any obligation on the part of the public authorities to respond.
Yes, and my submission will be along those lines that the suggestion that the state saying to an individual in that situation, yes, you may stay on these conditions, yes, we'll give you permission to be in the country on that basis, is a long way from limbuela, and is not at all readily defined as a scenario which can be described as treatment or mistreatment, which brings into play the system's duty under Article 3. One is a long way from inflicting inhuman and degrading treatment when the state gives an individual permission to stay in the country on the basis of certain conditions. None of that takes away the concession made and the obligations that arise when the individual then comes some years down the line and says, my circumstances have changed, I'm now in dire straits, please help me, please provide me with recourse to public funds. But I'm saying it's an ambitious submission to say that the initial grant of permission on those terms is treatment for the purposes of Article 3 that is comparable with limbuela.
But is that what's being challenged? It's not the terms of the original limited leave to remain, it's the refusal to lift, rightly or wrongly, the refusal to lift the NRPF condition if the applicant says, I'm a single mother, I've got a 2-year-old child, there is no no grandma around the corner, what do you expect me to do?
My lord, you have gone right to the core of what makes it such an interesting case.
Good. Well, we'll resume that argument at 10:30 tomorrow.